Professor Epiphany Azinge, a senior advocate of Nigeria, is celebrating 40 years at the bar. He has always said that the country does not have enough lawyers to serve its population. The senior advocate of Nigeria believes that Nigeria is grossly underprepared for litigations and other related services. It is his opinion that many yawning gaps need to be filled in the nation's legal system. But with the novel coronavirus, which affects the very core of our survival, it is clear that new strategies are to be adopted for the judiciary to meet up with the best practices. So, what are the lessons that we can take away from the new normal? Well, for more on this, I've now been joined by Professor Epiphany Azinge, a senior advocate of Nigeria, who is celebrating 40 years at the bar. Very warm congratulations.
Thank you very much.
40 years is a huge milestone.
So, certainly, yeah.
But let me start. What would you say are the challenges facing the Nigerian lawyer or the bar today? There are so many infractions against the bar. If I may even want to use the upcoming 2020 NBA elections, there are lots and loads of acrimonies. But what are the main challenges facing the bar today?
Well, we started with very, very manageable size of lawyers at a point in time. But we have obviously escalated to the point that at this stage we should be about 120, 140,000 Nigerian lawyers. That's quite a high number at this point in time, not in terms of comparison or relating to the population, but because we are still struggling to find how to fit in this huge number within the framework of what is available, and how obviously we can sustain them and make sure that they make a very good living out of the system. And to that extent, it's a huge problem, the management and the issue of sustainability to a very large extent of those people who are in practice. Again, we need to talk about remunerations, as the case may be, for these young ones.
I was just going to go to that, you know. Is that why the young lawyers in Nigeria are grossly underpaid, as little as 30,000, 35,000? Is it deliberate?
No, certainly not. It's what the system can afford at this point in time.
When senior advocates like you for a brief, just to come and get my brief, you're talking of 10 million, 20 million straight away?
Well, that may well be the case, but the truth of the matter is that we have to now talk about what percentage of lawyers are senior advocates. Not even about 1%. So which means there's still a lot of room up there for people to struggle or strive or aspire to get there. But for me, the issue is one of working out a structure, a mechanism or system that can help to sustain the younger ones. And that's why it is often believed that we are getting too many at the bar for us to be able to sustain the quality and the standards we need, inclusive of the issue of remuneration. How many people can afford to? Not many lawyers are senior advocates. So how do you generate the necessary funds with which to pay some of these younger lawyers? That, for us, is a major problem.
I thought in some of your submissions, you said that the lawyers are kind of, underrepresented. Particularly when it comes to litigations. You said it, about 130,000, 140,000 in a population of 200 million.
In terms of comparison, yes, relating to. But the point is that the economy of a system is very, very critical. You can have almost 500,000 lawyers in the United States of America. I believe they have the economy to sustain that. In Canada, you can have 300,000. 150,000 or 140,000 in an economy of our standard is something that is grossly not enough for anybody to sustain lawyers as we want them to be. A very, very respectable, noble profession. To that extent, there are certain standards that have been laid down by certain bodies, institutions, and mechanisms within the legal profession To that extent, nobody expects that a lawyer, properly so-called, should fall below that standard. And that is a challenge on its own. And for us, it's a question of trying to inject more resources and funds in order to actualize that objective of making sure that everybody who is called a lawyer, or anyone who is called a lawyer, is well equipped and adequately remunerated in such a way that he can sustain a lifestyle that is both respectable and noble at the same time.
Very well said. Everything seems to depend on sustainability. So if I may ask, should law in Nigeria be a first degree course or a master's degree course?
Well, theoretically, one may argue, and I belong to that school of thought that believes that law should be a graduate program. Why? Because increasingly we've started seeing, regrettably, falling standard of legal education and falling standard of the quality and capacity, competence of those who have been called to the bar. It is no fault of anybody. I've also argued and posited that a good number of these are fallouts of the quality of education we have coming up the ladder, either primary school, secondary school, up to the university. I often joke about it that we don't teach English in law classes, neither do you in the law school. So you don't expect somebody who has had half-baked education, not necessarily submitted or subjected to the lessons from brighter grammar English. Suddenly, when you come to the law faculty, you start speaking perfect grammar. You know, it's not that way. It's rocket science for you to just, from nowhere, you know, flourish as far as English language is concerned and speak impeccable English. So to that extent, the challenge is there. And if you flow from there, you can say, yes, there's merit in the argument that we should have a graduate program. One, it will help to whittle down the number of people, because by the time you finish with your first degree, for you to make up your mind whether you want to continue again to go into a law class, you may have to weigh it properly.
Will it be an aggregation of various knowledges? I mean, if I'm coming with a first degree in the sciences or in the arts or in the social sciences, I could just go straight and read law?
No. There are so many people that read mathematics. One of the best jurists ever in the history of the world is one that is reputed to have studied mathematics, and to that extent, anybody from any field can do well in law. Law does not exclude any of the disciplines. But one thing that is very, very clear is that your capacity to assimilate and comprehend, your analytical mind, elevated thought process, and that comprehension of logic, factually and otherwise, is something that is not given to ordinary minds. So to that extent, we believe that a graduate program may well assist, one way or the other. One, to whittle down the number and to make sure that the quality coming in. But, and this caveat is very important, from experience in the law class, you have seen that in some instances, those who are starting from SS3 coming to the law faculty, a good number of them have done better than some graduate students. So that argument is still there, and one cannot put it under the carpet. So whilst we are positing that it is important for us to go through the graduate program before getting into law, we can also have it at the back of our mind. It does not necessarily serve the purpose at all times, because there are still some young ones who have done far better, going in straight from secondary school, and they've excelled where the graduate students have not excelled.
Okay, let's look at the Nigerian Institute of Advanced Legal Studies. You once headed for quite a number of years as its Director General. How much impact would you say this institute has made into the legal professions? If there are dwindling qualities like you painted, has it helped to show up, you know, quality and value-driven lawyers in the country or the legal system? Well,
since its inception, the Nigerian Institute of Advanced Legal Studies have made and continues to make, even presently, because successive directors general, those that took over from me up till the present moment, they've been doing exceptionally wonderful work, trying to protect the mandate and preserve it and push it beyond limits. So to that extent, I congratulate my successors for the good job they've done. One, basically, the advanced legal studies is there for continuing legal education. That is one of the basic mandates, continuing legal education. So where we think there is a deficit or deficiency, as the case may be, we want to try to educate and improve on the conversation, try to enhance quality to the best of our ability, build capacity to a very large extent, and make sure that if there are emerging areas in law, to that extent, we try as much as possible to introduce people who are already lawyers into that emerging area of law. And to a very large extent, we engage in field research to a large extent. I'm sure that a lot of work is going on at the Institute at this point in time, as far as COVID is concerned, and the way forward as far as the legal profession is concerned too. So emerging areas, new areas, how to build capacity and obviously open up new vistas and push the frontiers to the best of our ability. That is what the Institute is there to do, and of course they are doing a very wonderful job. Whilst I was there and thereafter, I think they are living up to the mandate. And
you have collaborative efforts
lot of it.
Within and outside the country.
A lot.
With
MacArthur Foundation, so many, both in US, UK. We also help to train people for prosecution, legal drafting, and so on and so forth. And a lot of work is going on independently in various areas of law, whether it has to do with process of crime, whether it has to do with money laundering, whether it has to do with competition law, all facets, all aspects of law, well interrogated, and they are doing so resoundingly well.
Let me start with the issue of corruption. Corruption in the bar and the bench. And when they say the judiciary is the last hope of the common man, then it automatically becomes ashes in the mouth when people talk about corruption in the bar and the bench. What are your thoughts here?
Well, a lot left to be proven, in the sense that the public perception is one thing, the reality on ground is another thing. Certainly, we've had instances in the not too distant past that of people or judges who have been accused of corrupt practices. Mark you, a good number of them ultimately were obviously exonerated. Few others, for one reason or the other, were also asked to take a bow and go, which is what exactly the inbuilt mechanism as operated by the National Judicial Council is there to do. They have to sift to find out whether truly, in all honesty, with evidence available, to know whether truly somebody can be deemed to be really corrupt in that regard from the evidence available. So what I'm trying to get to is the fact that we have inbuilt mechanisms for some of these things, and that has been clearly articulated over a period of time, that the judiciary in this country, through the instrumentality of the National Judicial Council, have the wherewithal to sanitize itself, and you don't need to. So when people make elaborate complaints about corruption in the judiciary, occasionally you wonder, because what the NJC seem to have brought to the fore is not exactly what the public is thinking and what is provable as far as the matter is.
You have to look at the public from the perspective of seeing the judiciary as only next to God.
Yes, we have not lost that position. The judiciary has not lost that position in this country. And again, we proceed from the premise that, you see, how many judges and justices do we have in this country? If we count them all over, you can understand that it's quite a sizable number. But when 2 or 3, expectedly, 2 or 3 may obviously wander and drift, and as the case may be, that
gets entangled.
For sure. And that does not warrant a blanket statement that the Nigerian judiciary is corrupt. Nigerian judiciary is not corrupt to that extent. And the Nigerian judiciary is one of the best we can think of in the world. So that we project that as an argument, that we have one of the best and brightest as far as the world is concerned in terms of our judges. Judicial pronouncements made in this country carries a lot of weight all over the Commonwealth and beyond. And occasionally, in recent times, by the time we start comparing the pronouncement of judges and what they do in the United States of America, like recently, the issue pertaining to Trump, amongst others, that the Supreme Court of America handled, you look at the judgment and you read through that judgment, you begin to wonder, is this really the same judgments that we used to read about the Frankfurters, amongst others, the Madisons and the rest of them in the United States Supreme Court? You have better judgments in this country, Nigeria, at this present time. So what we are trying to say is that we have to promote the good aspect of the judiciary. They are seasoned, learned, and they write very, very impeccable, flawless judgment. Yes, there are some mistakes here and there, expectedly, but that is one aspect that we must give credit to the judiciary. As far as the lawyers are concerned, the Legal Practitioner Disciplinary Committee is there, it's in place. All you need, whether you are within the bar or you are outside the bar, all you need is a petition. And you can get a lawyer to help you author the petition. And you put it before the disciplinary committee. They will always listen to it. They will always write for the lawyer to explain. And obviously, in some instances, they will invite you to appear before the panel. So the same thing for the people who are already wearing silk, the senior advocates. They are also inbuilt mechanism for discipline as far as the LPPC is concerned. So to that extent, you see that ethically, most lawyers will not want to wander adrift because they know that the sanctions are there, the punitive measures are there. And with that, we are able to make sure that we sanitize both the bar and the bench within the framework of what is on ground, as far as the National Judicial Council is concerned, and as far as the other entities created within the legal profession itself to sanitize erring practitioners, as far as those ones are also concerned.
Well, ethically, you said, ethically, some Nigerians would say the Nigerian lawyers and judges may have wandered away, particularly when lawyers come with frivolous applications, and the judges, they will just say they are no Father Christmas, is what is presented before them that they will adhere to and grant such, you know, bringing a case from Edo State where you have a federal high court or the state high court, two courts of coordinate jurisdiction, and bringing it to Abuja when ordinarily it shouldn't be domiciled there. How do you describe that, Prof? Well,
it's part of the secrets of the profession and the trade practices that we are conversant with.
That the public is not conversant with. Because whatever the case, the lawyer is going to collect his fees.
No, the point is that if we allow certain things to endure, that will be a big problem for us. But the happy news is that a lot of work is going on to sanitize some of those things and to make sure. Well, we have seen the issue of the Administration of Criminal Justice Act that provides for day-to-day handling of cases. Judges must hear the case day to day, and within a period of time, given period of time, you bring it to a conclusion. If we try as much as possible to pursue that line, I'm sure that a lot of improvement can come. Yes, it is totally unethical. It is unwieldy for people to be forum shopping, so to speak, by moving from one court in one jurisdiction to another just to get what they are not supposed, which is very, very unfortunate. But the way I dismiss that, even if it is to just to wander a little bit adrift, is to say that most of these cases are political cases. Most of the issues that will lead to some of these interlocutory injunctions and what have you, if you watch closely, they've always been political cases. Well, now the challenge for us is, must the courts entertain all political matters? And that is another place that our jurisprudence seems to have drifted to a very large extent. I belong to the school of thought that thinks that there are some areas that should be within the province of the judiciary to intervene. But there are some that can be dismissed as political questions, and the judiciary ought not to go into that political ticket, as the American constitutional jurisprudence will tell me. We have neglected to follow the American direction. We have carved out our own direction. What is our business with primaries? What is the business of the court with who emerges as a candidate? It is not the business of the court.
Okay, in just 60 seconds before we go, Prof, you want to comment on your 40 years at the bar. How far, how well?
Well, I believe I give thanks to God first for being alive and still enjoying good health. I've tried to make the best of my contribution in terms of improving the profession to the best of my ability, either through research, legal advocacy, amongst other things. I have served to the best of my ability and the capacities I've found myself. I'm still serving currently in the Commonwealth Arbitral Tribunal as a member of that tribunal as a judge, and I'm representing Nigeria and the Commonwealth. I'm also giving it my best shot to the best of my ability. So going forward, as long as God spares one, we'll continue to strive to make sure that we continue to make contributions one way or the other. But most importantly, to bring up the young ones in a way and manner that will be befitting and beneficial to the country. That has been my goal, and that has been my objective.